Okay, part two. And right, feel free to ignore the image of me if you just want to focus on the slides. I'll just make absolutely sure this is recording. Okay, it is recording, yeah. Oh, okay, so let's carry on. So the Uruguay round was concluded in Marrakesh in 1994, where the parties to GATT, who became members of the World Trade Organization, members because they're no longer parties just to agreements, they're also members of an international organization with legal personality. So they signed the GATT Final Act, which is a very short document, in fact. Now, you may wonder what happened to GATT 1947. And if you look at if you download the text of GATT, you'll find it is exactly the same language as the revised 1947 original GATT. So how come GATT 1947 has become GATT 1994? Well, and here we get into, you might say, sort of legal fiction. We treat the two as legally distinct. And this through incorporation by reference. So the text of 1947 GATT is incorporated by reference into WTO law, right? So GATT 1994 is a short 2-page document, right, that incorporates all of the text of GATT 1947 with the various revisions, amendments, and annexes since 1947. So now GATT 1947 is terminated, is no longer in force, but the language, the provisions of GATT 47 remain in WTO law. So the text, as I say, so the text is still here, and here is the text of GATT 47, which is now part of WTO law due to its incorporation by reference. Okay, I think that's all pretty clear. Now, so note that the rules of GATT and all the rest of the covered agreements of the WTO agreement are binding only on members. So clearly there's an incentive for non-members to join. At the time, large countries like Russia and China were not parties to GATT, therefore didn't automatically join the World Trade Organization. In consequence, both Russia and China spent quite a long time negotiating with existing, let's say with the original WTO member states for quite a long period of time. China in total, it was 15 years. Well, that sort of began during the GATT period. For Russia, it was 18 years. And so China and Russia are now members of the WTO and must comply with the accession agreement. And accession agreements, because they are negotiated between a prospective, an applicant member and the existing members, can often include requirements that new members introduce rules and laws that are maybe actually stricter than WTO law actually requires. Those accession agreements, as I said some time back, are now part of WTO law. So if we give a kind of overview of the main principles and provisions of WTO law now, we can narrow it down to these ones. So there are rules on non-discrimination, which we've already looked at briefly, most favored nation and national treatment. Rules on market access, and rules on unfair trade. Unfair in the sense of, well, unfair, let's say, or arbitrary or discriminatory. Rules on conflict between free trade and other societal values and interests. So let's say non-economic interests. I mentioned a few before: environment, animal welfare, human rights, etc., etc. And then there are provisions promoting harmonization of national laws and regulatory practices. Right? Harmonization. They don't require harmonization, but they do tend to encourage harmonization. So let's look at these in a little more detail, right? With some illustrative examples and also some exceptions. So most favored nation is dealt with if we look at GATT. It's dealt with in Articles 1 and 2 of GATT, which is here, which is GATT, so the old GATT, but it's now the text of the new GATT. Article 1 is called a general most favored nation treatment, and Article 2 is on schedules of concessions. All right. So every single member of the World Trade Organization must have its schedules of concessions. Schedules of concessions are the tariffs we will apply to all these different goods. Right? And of course, MFN means that you must accord to the trade of other members, WTO members, treatment that's no less favorable than that provided for any other member. Right? And those schedules, once you have submitted them to the WTO, then those are binding on you. So you make commitments, you make promises, and you have to stick to them. Right? Now, national treatment is covered in Articles 3 and 4 of GATT, and they apply not just to border measures, but also to internal taxation and internal regulations. And there are some concessions. So Article 4 provides special provisions relating to movies, to films. And why are there special provisions? Basically providing an exception relating to films, because certain countries wanted to, particularly, not necessarily countries which have whose national language is not English, wanted to protect their language really from in terms of culture, cultural work, particularly movies. So the French particularly were concerned about the French film industry being destroyed by Hollywood dominating, and the French can sometimes be a little bit protectionist about their own language and their own culture. So there is an exception for movies for the benefit of the French, also the Canadians. It might partly be the French Canadians, but also Canada is, of course, a country that shares a very, very long border with the United States. And Canada sometimes wants to assert its identity as being something that is distinct from the United States, even though mostly, apart from Quebec, the language is the same. So the Canadians also were concerned to protect their local movie industry by being allowed to impose screen quotas. In other words, requiring that cinemas show domestic movies for a certain percentage, maybe 50% or whatever, of movies. Now, non-discrimination is in relation to what, actually? And how do you determine whether there is discrimination? Right? Let's supposing you treat apples differently from oranges. Well, they're both fruit, right? Are they in competition? If there are no apples in the market, do you buy oranges instead? And vice versa. That sounds like a silly question, but actually it's not it's not to be scoffed at, because it's actually quite important. What about Arabica coffee or Robusta coffee? What about coffee and tea, right? Because discrimination concerns what are called like products. What is a like product? Okay, so, and what is the relationship between a like product? So how do we classify products, right? And even if we have a classification which shows these two products are in the same class, does it mean they are like product? Because really, at the end of the day, it's really about the market. Are these substitutes? Are they replacements? Right? And if there is such discrimination in relation to like products, how is this likeness, not only how is this likeness established, but how do we determine whether there's discrimination, and must there be intent? Well, let's look at a couple of examples, right? Okay, that's actually the same question. I'm not sure why I said it twice, but anyway, let's move on. Okay, so I mentioned about national treatment, including things like taxation, right? This is an example of a real dispute at the World Trade Organization involving Chile. And Chile imposed taxes on alcoholic drinks for the domestic market. And the taxation percentages were on a scale according to how much alcohol there is in the drink. So when you have beer, which is, tends to be, 4 to 5% alcohol content, which may go up to, let's say, whiskey is 40%. So Chile had this scale of taxation. Now you might say, well, there's nothing actually wrong with this. That's quite normal, right? And in what way would it be discriminatory? Well, okay. So here we have to weigh up the question, one, why are these different drinks competing? Right? Well, that's something to consider. But it's not the only thing to consider whether Chile was doing something wrong here or was in violation of trade law. Because then the question arises of what sort of alcoholic drinks do Chilean alcohol product makers actually produce? What kind of drinks do they produce? So one are the different products substitutes? Because if they're substitutes, then they're clearly like products. If they're not substitutes, maybe they have still some likeness, right? So questions like, are drinks of different alcohol content in competition with each other? Are they substitutes? If they are, does this mean they are being similarly taxed or not? What about imported drinks? Are they being subjected to equal tax burden or not? Okay, so that's now the important thing. Supposing Chile only or generally produces, right? Chilean producers generally produce alcoholic drinks that are relatively low level of alcohol content and are subject to lower taxes. Right? What about import? Let's say, think of the UK. UK is a big exporter of Scotch whiskey, which is much higher, right? So here it starts to get interesting. So British exporters, if they are primarily exporters of whiskey to Chile, will be subject to the higher rates of tax, whereas the local domestic exporters, which tend to produce lower alcohol content drinks, will be subjected to a lower tax burden. Right. Okay, so in this particular case, and you may find it slightly surprising, that weighing everything into consideration, the appellate body of the World Trade Organization in its report took the view that Chile was not treating like products with a similar tax. And because the like products that were suffering this discrimination were foreign, were imported products, whereas the tax burden on the local producers was lower, this was a discrimination. In other words, Chile was discriminating against foreign importers. Therefore, Chile had to change this tax regime on alcoholic drinks. Right. Slightly controversial case. I mean, one could see reasons why you might argue actually the opposite. I know just one more thing in passing is that nobody had to prove that Chile, the intent was to actually discriminate. So it wasn't by intention; it was by effect of the tax regime. Another kind of discrimination on the basis of most favored nation, MFN discrimination. Now, so Spain, and this is actually an old GATT case, so not pre-WTO, but okay, of course, it's the same language at issue. So this is an old GATT panel report, but it's a very well-known one, Spain-Unroasted Coffee. Right. So in, I think about 1979, Spain introduced a tariff regime for unroasted coffee. And within that tariff, the tariff schedules for unroasted coffee, they divided up unroasted coffee into 5 different classes. A, Colombian mild coffee. B, other mild coffees. C, unwashed Arabica. D, Robusta. And E, other unroasted coffees. Okay, so 5 different types of unroasted coffee, right? So, and Spain made A and B, it's Colombian mild and other mild coffees. So mild coffees were all subject to 0 tariffs, no tariffs at all. So no tariffs were imposed on A and B. On the other hand, there were 7% ad valorem duties imposed on the others. Now, it might seem rather odd that the tariffs go from 0% on some types of unroasted coffee and others, there is a 7% tariff imposed on the other ones. Now, the sort of possibility here is that Spain wanted to provide some preferences for exporters from former colonies, so former Spanish colonies, which I guess would be ones in West Africa. And of course, it's hard to see why these are not like products. Surely these are all like products. I mean, why wouldn't they be? Now, it so happened that Spain exported to, so Brazil exported to Spain almost entirely Arabica, and mostly Arabica and some Robusta, but not the others. And so this complaint came from Brazil. It said that, you know, you are providing favors or advantages for certain countries, but because all our coffee we export to you is in the form of those classes of coffee that are on which tariffs are imposed, this is the discrimination. So, of course, as you might expect, Brazil won this one. I think this is probably easier to see how Brazil won this one than to see how Chile lost the other. So I'll leave that up to you to think about. All right. A couple of things to mention here. is one is that how do countries classify products, traded products, for the purpose of tariffs? Because there are two obvious ways to assess likeness. One is to say that they are like products under the World Customs Organization's harmonized system. So that WCO system is one that a lot of countries adopt and is globally recognized. So this is a way of classifying goods. And many WTO members use a system on their tariff schedule. So it's kind of an international norm now. So if you see that these products are coded the same, then they're likely to be like products. But of course, it's not just about that. Even more, it's about the competitive relationship of goods. Are they competing? So I mentioned before, Apple is competing with oranges. They're both fruits, and yet they're not, are they? They're not necessarily not likely to be competing with each other in the way that other things are, much more obviously. Another important issue which comes up is about whether products are necessarily like, even though they have the same product name and physically they are identical. Is there any way that products that are called the same thing and are physically identical are not like products? And this is been a difficulty for World Trade Organization panels to consider. But certainly there is scope for saying they can be not like. So to give you an example, actually a real example, a product that is made, an industrial product that is made by prisoners, right? Or let's make it even worse here, a product made by slaves, right? Is that physically the same as an identical product that is made by well-paid workers with full rights to get paid and to be treated well in their place of work, with pensions, etc.? The two products are exactly the same, of course. And so they are exact substitutes, except where one is shown is to the consumer, it is visible to the consumer, right, that this product was not made by slave labor, and two, that the customer makes choices on that basis. Right? So if the customer chooses, and there's a branding, there's a label on the product to show that this product was not made by slave labor, the consumer is therefore able to make a choice. And if the consumer exercises that choice, then perhaps these are not like products anymore, even though they are physically identical. Another real example is that tuna fish. Now, tuna is of course a popular food around the world. The way that tuna are caught is important to a lot of people, right? Because dolphins often swim near tuna, and I suspect all of you probably think, dolphins are nice creatures. We wouldn't want to eat tuna which was caught in a way that causes the death of dolphins. We would probably like it if tuna was caught in a way that left dolphins unharmed. The tuna caught this way or that way is going to be obviously exactly the same thing, right? But if there is on the tin, it says dolphin friendly or dolphin safe, set against tuna that where there is no such label, then the concerned customer who is aware and observant and cares about dolphins will treat these two products quite differently. They will choose one over the other. And if enough people are like this, they choose the dolphin-friendly tuna over the unlabeled tuna, right? Those products are no longer like products. Now, the term used in this kind of circumstance is, well, there are PPMs or production and process methods, but these are non-product related production and process methods, right? NPR PPMs, yeah, I mean short, and where these do affect consumer choice, they can make products non-like. Of course, there are also PPMs that do actually change the physical characteristics of a product. I might cover those later because the non-product related ones are perhaps a bit more controversial because there are arguments both sides to say that they are like under the World Customs Organization system, there would be like products, but in terms of the market, they maybe become non-like. All right. Okay. Of course, there is the issue of national origin of goods, and there's been much talk recently, particularly with this pandemic now, is that China is very much integrated into production chains of goods, and that's become very evident now. But what are the rules regarding origin? You know, there are certain goods that are assembled, parts of the goods are assembled in different countries. And as they are being assembled, or different parts are being assembled, they move around the world. Right? Well, there is a certain amount of clarity in trade law, a certain amount of clarity. There's agreement on rules of origin. I'm not going to say much about this, but rules of origin are important in terms of how you impose tariff, right? It might be that, let's say, a car made that's mostly built in the UK, but maybe the final assembly or parts of the production may take place in another country, and then it's brought back into the country where it is finished and then sold. So when you bring them back into the country, is that counted as a foreign good, or is it a domestic good? Obviously, that affects the tariffs that you might impose and how you treat that good, whether it's an imported product and where does it come from. So that here is the relevant provision of the agreement on rules of origin. Rules of origin should provide for the country to be determined as to the origin of a particular good, be either the country where the good has been wholly obtained, or when more than one country is concerned in the production of the good, the country where the last substantial transformation has been carried out. Right, the last substantial transformation. That doesn't have a definition, I should note. Okay, so in Marrakesh in I think December 1994, we came up with this agreement, the agreement establishing the World Trade Organization. And I'll say all the other agreements are attached to it as annexes. Yeah. So the agreement establishing the World Trade Organization, the WTO agreement, consists of 16 articles and over about 9 or 10 pages, so it's quite short, right? This agreement is important in a way because it deals with institutional matters, ministerial conference, the General Council, and the different councils for the different covered agreements, but it also states the objectives of WTO, right? And what are the objectives? Well, as with most agreements, you look to the preamble, which provides at the beginning, which provides the general sort of principles and rationales for the treaty, for the agreement. So here's what they are. It's increase standards of living, attain full employment, growth of real income and effective demand, expand production of and trade in goods and services. So increase standards of living, ensure or to attain full employment, contribute to the growth of real income and effective demand, and expand production of trade in goods and services. Okay, so those are the 4 primary objectives. Right. So all good things, obviously. So this is what the international trade regime is intended to achieve. But there are other priorities. One of these is sustainable economic development. Right, sustainable development. Now, the term sustainable development goes back to the late 1980s, because if we cast our minds back to this period, the late 1980s, early 1990s, at the same time as the Uruguay round was taking place, there was another legal process going on, which was to deal with problems in the global environment. And the 2 main problems requiring multilateral legal action were 1, climate change, and 2, the loss of biological diversity. Tied to these environmental issues were concerns about developing countries. How are developing countries going to grow and develop and prosper while we protect the environment or protect the earth from human-caused climate change and the loss of biodiversity? And so the former Prime Minister of Norway, Brundtland, was appointed by United Nations to set up a commission on environment and development. And he produced a report called Our Common Future, in which this term sustainable development was proclaimed as a primary objective of the global community. And so the Uruguay round obviously incorporates this concept as well. So you see the term sustainable economic development, development that meets the needs of present generation without compromising the needs of future generations. So the idea is that we should look after the planet while we grow our economies, so that future generations will have as much as we have, if not more, to keep on developing in a way that improves human lives without damaging the environment. And another priority is the integration of developing countries and least developed countries in the world trading system. So this is the opposite, you might say, of dependency theory and import substitution. We now integrate. We don't separate. We don't go our own way. We integrate all countries, rich and poor, into the world trading system. Okay, so that's the term sustainable development, which I just mentioned. That's the definition from the Brundtland report, Our Common Future, published in 1987. It was, okay. And how to achieve all these good things? By reducing tariffs and other barriers to trade and eliminating discrimination in trade relations, so reducing barriers to trade and eliminating discrimination. That's the whole text. I've just given you a summarized version of you to look at in your own time. Do I need to remove myself out of the way so you can see the text properly? Yeah, there we are. Corner there. All right. Okay. So in 2011, which was only 6 years after the WTO started, we find that there were 153 developing countries, at least developing countries, members of the WTO. 110 out of 153 were developing, at least developed countries, and membership has increased since then. There are now 164 members of the WTO. That comprises about, I'm guessing here, probably about 95% of the world population lives in a country that's a member of the WTO. All right. Okay, let's return back to GATT. A few other provisions that I wanted to mention. Sorry, this sort of switching, but I just briefly wanted to say about the WTO agreement because that's an institutional matter. It's about the purpose of the WTO. So GATT. Other provisions that are very important. One is freedom of transit. There was a few years ago a dispute about this freedom of transit when India made an agreement with Brazil to supply certain medicines. These medicines that were manufactured in India and were to be exported to Brazil. And these medicines needed to be sort of looked after and kept in the right conditions so that the medicines are still viable and not spoiled along the journey. So they were transported via Amsterdam airport and stored there for a while to be kept or to be transported over to Brazil. And well, there are no direct flights between India and Brazil. So they were being kept in a warehouse at Amsterdam airport. Now, under Article 5, freedom of transit, the authorities at the airport were required to just wave them through so that they could reach Brazil without them being seized or anything. What happened was that a number of patent owners who have patents in Europe, there are no patents on the medicines in India or in Brazil, ordered the authorities, we got a court order requiring that the authorities seize these medicines and not pass them on to Brazil on the basis of patent infringement. Brazil and India complained at the World Trade Organization against this measure, which was in relation to a European regulation. Discussions are ongoing. Let me just say that it seems to be a fairly clear case that this was a violation of Article 5 of the of GATT. Right? Another article to mention, important GATT provision concerns anti-dumping and counterfeiting duties. Right? Dumping. What is dumping? Dumping is exporting products at less than the normal value of the products, and of course, there is an assumption that it does cause or threaten injury to an established industry because it is unfair. I mean, dumping is unfair, right? It can damage an existing industry, or it can actually retard or delay the establishment of a domestic industry. So, what can parties or members of the WTO do to deal with dumping under GATT? They are allowed to levy countervailing duties or countervailing opposing corresponding. And those duties can be imposed, but not greater in amount than the margin of dumping in respect of such product, which means that dumping is wrong, but the right way to respond to dumping is to you're allowed to impose these duties, but countervailing duties are subject to a discipline. You can't use these duties to punish or be excessive or be a disguised unfair trade restraint. So they are subject to a discipline. Yeah, you can do this, but you can't go too far. All right. And a couple of more things I want to mention in relation to traded goods, because I also need to talk about dispute settlement and get to that subject. First, security exceptions. You may be aware that President Trump imposed sanctions, let's say sanctions, not sanctions, but heightened tariffs on steel and aluminium from Europe and China, and he invoked national security. And why would he do that? Because, well, it seems not to be, it would appear not to be entirely a genuine reason. I mean, there are reasons why you might do this. But to call it a national security basis, the advantage of doing this means that you don't have to really to justify it, right? Security exceptions don't have to be justified like other things that you do. And there's never, as far as I know, been a dispute, a complaint when a country imposes a security exception, because in a way, every country wants to reserve their freedom to apply security exceptions sometimes. So even where a country may abuse it, they won't necessarily raise a complaint, because the vagueness and the lack of legal bindingness to control, in terms of the existence of measures to control the use of national security, or invoking security as an exception, is something countries want to, generally, most countries would like to see still there. They don't want a strict definition and strict control over national freedom to use as exception. Article 24, which is extremely important. Article 24 concerns customs unions and free trade areas. Now, what is a customs union? A customs union is a union of countries that operate as if they are a single country for the purpose of imposing tariffs on non-members of the customs union. So if you think of the European Union, it is a customs union. And this means that the borders of the European Union count as if they are a single national border. So the EU has tariff schedules, not individual EU countries. In fact, individual EU countries are not allowed to negotiate separate trade agreements with non-members that would involve the establishment of another free trade area or a customs union, because in a sense you operate as if you are a single country with a single tariff regime. And if you look at the WTO schedules, you will see there are no EU member individual countries that have their own schedule. It's just the European Union. Now, a free trade area is like a single market, right? So how is a customs union and a single market different? Well, a single market, if you think about Europe, Switzerland is in the single market, but it's not in member of the EU. It's not a member of the customs union. So you'd be a customs union, single market. The two are slightly different. So a single market means for the purpose of trade, there are no borders, internal borders, right? But if you're in a free trade area, it doesn't preclude you as an individual country from negotiating your own trade agreements with other countries. And the importance of all this is that customs unions and free trade areas are allowed to favor each member country better than non-members. This obviously conflicts with the normal application of most federal nations. I mean, in the customs union, France and Germany treat traders of those two countries better than France and Germany treats importers from Korea or Japan or the United States. Clearly, that is a violation of most federal nations. But Article 24 makes it legal. It is allowed. It is an exception, a derogation from most federal nations. So countries which have these comprehensive trade agreements with other countries or regional trade agreements, they are not subject to most federal nations in the sense that they are allowed to treat other countries that have signed this or that are members of this agreement. They are allowed to treat goods from those countries more favorably. Okay, and then dispute settlement. Here's we come to dispute settlement. Now, Article 22 of GATT, the title is consultation. And Article 23 is called nullification or impairment. And Article 22 and 23 form the basis of the GATT dispute settlement system, which has now been updated thanks to Annex 2 of the WTO agreement, which concerns the DSU or the dispute settlement understanding. Now, consultation. Now, basically, if countries have a disagreement, so if one country says that your trade policy or your law or your regulation is discriminatory against our goods, you must agree to us having a discussion to see if we can settle the dispute. So the idea is that the two countries in dispute should discuss everything first. Now, what happens then is that the dispute may be settled, but maybe it won't be. Maybe they won't be able to agree, right? And then it gets sort of, we move on to a whole system here. I'm just going to pause this for a second, and I'll restart in just a minute. So what do we mean by nullification or impairment? Well, to nullify is to make to zero. To impair is to break or harm or damage. All right. So nullification or impairment refers to a situation where a country's law or policy is discriminatory against the goods from another country, and that discrimination, or other countries, not just another country, but it might just be they're all foreign countries. And that causes, that has the effect that the victim country or the plaintiff is not is being deprived of enjoyment of the full benefits of being a member of the World Trade Organization, to nullify and impair. So Article 22 and 23 form the basis, the legal basis of the dispute settlement understanding. So what does the dispute settlement understanding say in effect? So I'm trying to change page here. Here we are. Okay. Well, before I come to that, I just want to say that there are, in theory, 3 types of complaint. One is where the nullification or impairment is caused by a violation or an alleged violation of WTO law, violation complaints. The second type of complaint a country may make against another is on the basis of nullification or impairment where there is not necessarily, or there's not a violation, a non-violation complaint. Right. In this case, a complaint is on the basis that a country has been harmed by another country's discrimination, even though there isn't necessarily an actual violation of any provision of WTO law. Well, this is quite hard to prove. The third type of complaint is any other situation. If you look at the language of Article 23 of GATT, it refers to any other situation. The thing is, nobody knows what any other situation actually means. So you may not be surprised to know that there has never been any other situation complaint. No one knows what it means. It's hard to know what was the intent of this provision in GATT. You'd have to go back to 1947 and see why are these words there, and nobody, I don't think anybody actually knows. So in fact, virtually all complaints are violation complaints, complaints that nullification or impairment has been caused by another country's violation of WTO law. Right. Now, it's important to, or it's interesting to see that there's quite a high success rate of complainants. The ones who make the complaints are 90% successful, right? But compliance disputes are quite common. I'll explain what I mean by that shortly. So what does the dispute settlement understanding say? Well, first, it takes a view, as you would expect, that where there is a difference between 2 countries, the country making the complaint should request consultations in the hope that you settle. It's like out of court settlement. Let's just make this quick and easy. So the ideal thing is if the 2 countries settle their dispute without anything else happening. But often that does not lead to an agreement, and so it then becomes more formal. The complaining party will then request that a panel be established to assess the legality of the provisions of or the behavior of the complained about country. That panel consists of 3 people. It is an ad hoc panel, so the panel is appointed in relation to a specific complaint, a specific dispute. Those panelists will comprise usually experts, sometimes diplomats. The nationalities of those 3 panelists will be different. Will not be of either country involved in the dispute. That panel will consider the the arguments and the defenses, and will produce a report. Will produce a report, and that report will be it'll be a very much a sort of legal report, which will come to a conclusion. Right? It might say that that this country is in violation of this provision, but perhaps not that one. It might say this country is completely in violation, or maybe it's not in violation of any of the covered agreements, measures, or provisions cited by the complaining party. Right? Now that that panel report will be considered by the General Counsel, or the dispute settlement body, which is the identity of the General Counsel when it is hearing to consider reports. And that report is normally adopted without any controversy. In the old GATT days, panel reports were adopted by consensus, which meant that if the losing party refused its adoption, that panel report could not be adopted. Well, that clearly is a bit of a problem. So since the World Trade Organization was established, panel reports are automatically adopted unless every party refuses, actually rejects it. This is what we call reverse consensus. So it's consensus the other way around, right? So a panel report is always adopted in effect, but it would take every member of the WTO to reject it for it not to be adopted. And that's not going to happen, is it, realistically? There's also a 7-member appellate body. The appellate body currently isn't working for basically because the United States has basically refused any new appointments to the appellate body. But the appellate body is provided for by the WTO under the DSU, Annex 2 of the WTO agreement. And the appellate body is a standing body. So each member is 7 people, and they will hear all appeals. Right. So if the losing party appeals against the panel's recommendation, then the appellate body will hear the appeal, and I say those members, it's a standing body, so not ad hoc. They're there for members appointed for a few years. Now, according to the Annex 2 of the WTO agreement, which is the dispute settlement understanding on rules and procedures governing the settlement of disputes, and you do need to download all these documents, by the way, and they're all worth having a bit of a look. We call it the DSU for short, just for understanding. A couple of things to mention. One is that there is a clear attempt to settle disputes at an early stage, at the consultation. The second, where that can't be done, there's still the text does show a strong sentiment that things should be settled as quickly as possible. So there are certain time limits. Those time limits are not always kept to, by the way. But the idea is to let's sort this out as quick as we possibly can with as little fuss as possible. So what happens? What happens if a country loses a dispute? Well, they are supposed to, as quickly as they can, change that law, that regulation, that measure to make it compliant with WTO law. So the idea is that they should just change their law, and if that happens, that's everything is settled, the whole dispute. is over. Sometimes the country will say, okay, we've made the changes, and so now we are compliant. Well, what happens sometimes is that the winning party says, well, actually, no, you still haven't fully complied. Right? So compliance disputes are actually quite common. Actually, 15% of these disputes are not settled, right? And they lead to another complaint about the failure to fully comply with the panel report. Another thing that can happen is that the losing party says either doesn't do anything. They either say we're not going to do anything, or they just don't do anything at all. What happens then? So failure to comply, right? Well, then it may go to arbitration. Arbitration is quite a common way, but there are other consequences. One is that the losing party may actually pay compensation. So the winners and losers, that might be done through arbitration. The winners will pay some kind of compensation, right, to the winners. That sometimes happens. Another way is that on the basis of the cost of denullification or impairment to the winning party of the losing party's failure to comply, right, can be estimated, right? So, okay, so we won the case, country B lost the case, they haven't complied at all, they haven't done anything, okay? So we are bearing a continuing cost of nullification or impairment. Right. Well, so this is money that our economy is losing from this. We are continuing to lose money from the behavior of this other country not changing its laws, regulations, or policies. So we are going to request that the WTO allow us, right, to withdraw benefits of the WTO, right, to withdraw benefits to the same value. So we are allowed to retaliate, to cross-retaliate, and the WTO will, if the WTO approves that, so your retaliation must be to a value that is equivalent to the nullification and impairment you are continuing to suffer. So, in effect, this is with a certain withdrawal of MFN from the losing party to as I say, to this value of the nullification and impairment of non-compliance. Now, ideally, that is supposed to be done by withdrawing benefits from the same agreement, from the agreement that was in dispute. So, for example, if this is a dispute about technical barriers to trade, then ideally you should withdraw benefits under that covered agreement to match the losses. Sometimes it's difficult, but not feasible. And so you may request and get authorization from the WTO, the General Council, or the D667 body to cross-retaliate. In other words, to refuse MFN benefits from another covered agreement. I'll give you an example. The EU and United States had a dispute which also involved Ecuador about bananas, where the EU was favoring former European colonies and giving them trade advantages that were not available to some other countries, including Ecuador. So, and the Europeans lost, there was a further dispute about their non-compliance, or their compliance, or not non-compliance. And at some point, United States was able to impose trade penalties across other agreements. This has also been used against the United States. So, for example, the small Caribbean country of Antigua won a dispute against the United States under the services agreement relating to offshore gambling. United States was closed down access to these online gambling services provided by Antigua. Antigua won the case, so a tiny little country won a case against the United States. The United States said, we're not going to change our policy. We're not going to change our policy, even though we lost the case. So Antigua asked permission of the WTO because, clearly refusing benefits in terms of the service agreement was not really going to give Antigua any kind of satisfaction. So they also requested that they withdraw benefits under the TRIPS agreement. And that permission was given. Antigua has not actually carried out this. And the reason why is that they are dependent on the United States. And they are reluctant to antagonize the US. Okay. Important point to consider when you're thinking about whether whether dispute similar understanding necessarily makes formally there is equality between nations, but in practical terms, does it really work? That's an intriguing question. Okay, I'll just put this here, and I'll come back to these questions later. Of course, the World Trade Organization has encountered a large number of objections and disagreements. This is a book by Martin Wolf, who writes in the British Financial Times, a very well-respected journalist and a trade expert. And he actually came out with this interesting list of all the objections. It's not to say he agrees with them, but these are all the list of objections. And I'll come back to these in a few hours' time, because these sorts of objections are commonly expressed, and a lot of people believe in them. All right, I'm now going to move on to services, GATTs, which is Annex 1B of the WTO agreement. Services is a completely new thing under WTO law, completely new. Previously, GATT only dealt with goods, exclusively with goods. Now we have services. Services are quite a difficult thing to deal with, but clearly they are important. Services are, trade in services is growing faster than trade in goods. Back in the 1980s, early 90s, there was a lot of opposition to services being included in the Uruguay round. The reason being that, well, services are very important for the United States, but for a lot of developing countries, they have a much bigger trade interest in goods. Well, that's not necessarily true anymore. Not necessarily true anymore, because also developing countries also have now suddenly have a growing and increasing interest in services, and I'll look at the reasons why a bit later. Now, because services is quite a new thing in trade law, it's perhaps not so surprising that services don't, that the services agreement doesn't actually go very far. So the agreement basically it tells you what services are, where they are traded, which is quite important to know, But also the agreement does, it is in a sense a sort of negotiating mandate to liberalize over time. Right. So in terms of legal commitments, well, we'll see what the legal commitments are shortly. But first question arises, what is a service? How do they differ from goods? Well, the obvious thing is that they are not physical, but of course, services and goods are often tied together, aren't they? Not hard to think of examples. Can goods overlap with services? What about a service relating to a particular good or service supplied in conjunction with a particular good? Well, that's something to think about. Well, just as you have the World Customs Organization has a harmonized system to classify goods, there is also a United Nations system for services as well, or a system that does include services too. And well, if you have a look at these are a few examples. Dental cleaning, right? Taxes, museums provide a service. Of course, museums are buildings usually, aren't they? But they also provide, but they are services, right? Ski passes, legal defense for a murder trial, internet access. So these are all examples of services. So there is a classification for services as well as there is for goods. All right. So how are services actually traded? And I have to think about this quite a lot because I'm in the service industry. Well, the service is education, right? But how I deliver my service is quite varied, right? I work for a university. I'm employed by them. I suppose you could say I provide a service to my employers, but that's a little bit different, right? On the other hand, I do work for Chicago-Kent University. I provide a service to them who provide a service for you. I'm here in my own home here, so I'm not traveling. So I'm the service provider. I'm not traveling, but I'm using the internet, of course, to provide my educational service. Otherwise, I would be in Athens, or I'd be in Istanbul, or in Almaty, or Kiev, the other places where I go to do my work for Chicago-Kent. And look, with goods, the process is relatively simple. Well, okay, not exactly, because of course you have, the rules of origin agreement shows how origin itself is not necessarily a simple matter, particularly with complex manufactured goods like mobile phones or whatever, or aeroplanes. Right? So, but in this basic sense, goods are produced in country X and they're shipped to country Y where they're also sold. That's the sort of traditional, simple but traditional idea of how goods are traded. Okay, now, so services is a difficult one because previously it was assumed that they're not easily tradable. But of course, many service transactions do cross national boundaries without any physical contact, right? So, how do I get paid by a foreign business, right? Or university? How do I get paid? Well, the money is, the payment or the banking service does it electronically now, right? There's no crossing of a national boundary, no physical contact. It's all done through the internet. Electrons bouncing around doing the job. So it was hard to see how services could be regulated because not well understood how they are actually traded, and so there needs to be a good understanding of how they are traded, because of course they are, right? Key services tended to be state monopolies. If they're state monopolies, if water supply, or electricity, etc., telephone is a state monopoly, well, Should we regulate that? State monopolies, not private. Well, of course, 1980s was the time of the privatization, where actually public services were becoming private. So it was, I guess, the time when services could be considered as a trade negotiating item. And of course, those times were the beginning of outsourcing, external contracting, which again separates services from goods. So outsourcing. So, for example, if I have a problem with my internet, I may, or if I want to talk to my bank, I make a phone call. And where is the person I'm talking to? It might be a British bank. It might be an American computer company, internet service provider. It might be domestic, but I might be talking to somebody in India, right? So outsourcing customer services to another country is becoming increasingly common, and telecommunications, internet enable that. Okay, so there are under the services agreement, there are 4 different ways that services are provided. So from the territory of one member into the territory of any other member, what you might call cross-border supply of a service from the territory of one member into the territory of another member. I said Armenia here. I don't know because I think I was teaching in Tbilisi, and it could be Turkey, Greece, whatever. It doesn't really matter. So, for example, a Washington-based lawyer providing legal work for Georgian government, international phone call from England to Armenia, Azerbaijan, or wherever, where England-based caller uses Armenian telecom system to connect to Armenian receiver. Here, neither consumer or supplier crosses the border. So there's no physical connection between the supplier and the purchase of the customer of the service. Stay in your own country, which is what this, I guess, is what I'm doing now, right? So from the territory of one member into the territory of any other member. Although, of course, I'm in London, UK, but I'm in a way supplying a service for Chicago Kent Law School, who are in the United States. There you are, and where you are now is Greece or Turkey. In the territory of one member to the service customer of any other member, here is consumption abroad. The consumer moves to a territory of supplier. So a Bulgarian student attending Chicago Kent Law School in USA. Here you have consumption abroad, where the consumer crosses the border, but not the supplier. So this time, well, when you're going to go to Chicago, then Chicago Kent Law School is the service provider for the customer, and you go there. Right? Third, by a service supplier of one member through commercial presence in the territory of any other member. Commercial presence. Okay, and this applies to a lot of the foreign investment. So McDonald's restaurant in China, a foreign bank setting up branches in the country and supplying financial services. One of the textbooks says Euro Disney in Paris providing entertainment services. So a business will set up a branch in another country and they provide financial, entertainment, or food services. Right? That's commercial presence, of course. It might well be that all the employees or the staff are all employed locally in the country where the commercial operator is present. And then fourth, by a service supplier of one member, the presence of natural persons of a member in the territory of any other member. So here you have the presence of natural persons. So here you have the natural persons, I mean real people, right? who will go and provide the service. So it's provider moves rather than the customer moves. So the customer moving to the student moving to Chicago to study there. Here you have the person that's going to the place to provide the service. Think about some examples. A tour operator firm sending its employees to the tour destination to guide tourists. So, I mean, for example, a lot of Chinese, well, until recently, obviously, a lot of Chinese tourists will go travel, and a lot of people don't speak, let's get travel in Europe, a lot of people don't speak in European languages. So they'll have a Chinese person who speaks English, Italian, French, German, whatever, who will meet them when they arrive in Europe and will take them to the hotels and take them around all this. All right. So you have movement of citizens of one country to another country. And you have a fashion model modeling clothes in our country. Again, a fashion model is providing a service, but goes to the country to do that. So these are the 4 ways that services are traded, which are recognized in GATT, the General Agreement on Trade and Services. So what does GATT require of members? And the answer is, in a way, nothing. Right? What? Nothing? Well, yeah, actually nothing. But there's a big but to this, which is that members will engage in ongoing negotiations towards the making of specific commitments in 3 areas. So just as with GATT, you are supposed to make your commitments in terms of your tariff schedules. With the social agreement, you also have to have your schedules of commitments. And there are the commitments to be made are in 3 areas. 1 is market access. 2 is national treatment. In this case, national treatment applies only to those commitments that you've agreed to undertake. So, yeah. So it's not a general commitment of the agreement, it's just in relation to the specific commitments that you have accepted or you have promised, which are in the schedules, and therefore part of WTO law. So the EU has its own schedules of commitments, the United States and all other WTO members, Turkey, Greece, etc. And also additional commitments, which you may also make too. So these are all set out in the schedule of commitments. And once you've made your commitments, once they're in the schedule, these are legally binding. So your legal commitments under GATT appear once you have your schedules. So your schedule of commitments, once you have made those commitments, they are legally binding. Of course, there is this agreement to discuss further liberalization over time. Okay, so services is important because it's a huge area of trade that had previously been kept outside trade law. So including services itself is important in terms of what members must do. It's all about the schedules. There are no real commitments outside of the schedules that each member has to provide. Those schedules, of course, just like the tariff schedules, are an important part of WTO law, and together the 2 sets of schedules on goods and services fill most of the pages of WTO law, the pages that you don't have to read unless you have a very specific interest. Okay, I think I'm going to have a break now, and when I come back, or when you come back, we're going to go on to the TRIPS agreement. So I'm going to stop right now. And oh, okay, I'm going to stop now, and I will record it. Oh, so I'm trying to. Okay. Well, if you want to stop now, there's nothing to see here. You might as well just stop. I'm waiting for share.